Questions?
Thank you, Professor Blackman. Professor Foley, welcome.
Yep. Chairman Goodlatte, Ranking Member Conyers, members of the committee, thank you for the opportunity to testify again today. My criticisms with the President's immigration actions are based on legal process and not any particular policy or political results. What shape immigration reform may ultimately take is not my concern as a constitutional scholar. My sole concern is with preserving the Constitution and its separation of powers architecture. President Obama has repeatedly said that his motivation for taking executive action on immigration is because he wants to fix our broken immigration system. And what this means is that he's trying to fix our immigration law, because, of course, immigration law is the only immigration system that we have. So he thinks our immigration law is broken, and he believes that it's broken because it fails to exempt certain categories that he thinks deserve exemption from deportation and to whom he believes the law should grant benefits, such as work permits. But fixing a law by unilaterally changing it, by granting exemptions, remedies, and benefits that the law doesn't provide, is legislating, or to be more precise, it's amending. And that's a power that is given exclusively to Congress by the Constitution. The President's duty under the Constitution is not to fix a law that he thinks is broken, but to faithfully execute that law. When a president takes upon himself the power to change a law he doesn't like, we have no democracy anymore. We have instead a legislature of one. If Congress doesn't oppose President Obama's executive orders on immigration, it will be writing its own institutional obituary. When Congress fails to express disagreement with executive action, the courts tend to construe that as acquiescence or implied authorization by Congress. This is so-called Category 1 from Justice Jackson's concurrence in the Youngstown steel seizure case. So Congress needs to be very careful here. It has a constitutional responsibility to vigorously protect its turf. President Obama's immigration actions are unconstitutional for three separate and distinct reasons that I elaborate in the written statement. First, they alter the status of certain illegal immigrants, magically transforming them from deportable to not deportable. Second, they provide a remedy called deferred action that Congress has not explicitly or implicitly authorized for this category of people. Third, they confer benefits upon certain illegal immigrants that, again, Congress has not explicitly or implicitly approved for this population. While any one of these particular reasons will render executive action unconstitutional, when you have all three of them existing, as you do here with President Obama's executive actions on immigration, it creates sort of a Bermuda Triangle of unconstitutionality. It has a uniquely powerful gravitational pull that's capable of eviscerating Article 1's legislative powers. It's the combination of all three of these aspects of President Obama's executive orders on immigration that make it uniquely dangerous to this institution. I'd like to highlight 2 points that I elaborate on in the written statement that I think bear a little special mention. First, by granting work permits to DACA and DAPA recipients, President Obama's immigration orders encourage employers to hire illegal immigrants over lawful residents. And that's because the Affordable Care Act does not allow illegal immigrants to obtain tax credits when they buy qualifying health insurance. So what happens is if you hire more DACA and DAPA recipients, this lessens the employer's exposure to what's called the employer responsibility tax under the ACA. So the more illegal immigrants you hire who are eligible for DACA and DAPA, then the fewer who are eligible to buy health insurance, and the fewer who are going to obtain a tax credit for doing so, and therefore the fewer employees that you have on in your workplace who are capable of triggering that employer responsibility tax. Now, why do I go into that detail? Because it means one important thing. President Obama's immigration actions undermine the ACA itself by undermining its goal of providing insurance via the workplace. So it's no small irony here that by granting work permits to DACA and DAPA recipients, President Obama is in fact undermining his own signature legislative achievement. Second, DACA and DAPA recipients are eligible to apply for something called advance parole. And that means they can get advance permission to leave the country and come back relatively quickly. Without advance parole, if you enter this country illegally and you leave, you have to then stay out for a long period of time, usually about 3 to 10 years, before you're allowed to re-enter. So once a DACA or DAPA recipient re-enters this country after being advanced paroled, they're considered to be paroled back into the country, and paroled individuals under the statute are eligible to adjust their legal status. And they can do this as long as they qualify for a visa, such as, let's say, an employer-sponsored visa. So what does this mean? It means that at least for some DAPA and DACA recipients, obtaining advance parole will provide a
Professor
pathway.
Foley, you've exceeded your time limit considerably as well. Could you please summarize?
Absolutely. It means that they will be able to have a pathway to U.S. citizenship. This is problematic because Congress has the sole power to decide who's granted citizenship under the Constitution, and even if just one person under DACA and DAPA is granted advance parole and applying subsequently for adjustment of status, what we have is a fundamental usurpation of Congress's power over naturalization. Thank you, and I look forward to your questions.
Thank you, Professor. Professor Legomsky, welcome.
Okay. Thank you very much, Mr. Chairman, Ranking Member Conyers, and honorable members of this committee for the privilege of testifying at this important hearing. I appreciate that reasonable minds can and do differ about the policy decisions, but I want to respectfully share my opinion that the President's actions are clearly within his legal authority. That's not just my opinion, by the way. This past November, 135 immigration law professors and scholars joined in a letter expressing their views that these actions are, quote,